Buddy, thank you so much for joining us this evening. We're really excited to have you. Um, this is brought to you by Google and, of course, Neighbor to Neighbor. I'm Valerie O.T. Nellis, as Jim has said. And tonight we're going to be talking about one of our neighborhood passions, which is making government work for your neighborhood. And the topic is short term rentals, permitting, and enforcing. And we're really pleased to have Jon Michael, who is the zoning administrator with the Metro Codes Department. Our format's a little different tonight. We're going to be asking Jon Michael some questions, and then we're going to open it up to you all. Jim, are you ready with question number one?
Sure. And Jon Michael, welcome.
Thank you, Jim. May I confirm that my audio is up and running?
Yes,
your audio is up and running. You sound
great. So
much better than last week.
I apologize if anyone gets motion sickness as I'm riding along between family commitments right now, but I wanted to be able to join you tonight, and I'm pleased to do so on a subject that affects all of your neighborhoods, affects all of Nashville in so many ways. So by way of short introduction, my name's Jon Michael. I'm a lawyer with the Metropolitan government. I've been in my role as the zoning administrator for, 3 years now. I've been with the Codes Department for 6, after having spent about a decade with the Metro Legal Department. So since this stuff took effect, meaning the regulatory scheme for short-term rentals in 2015, it's all kind of been resting quietly and festering in my lap. And that stinks, but we're making the best of it. For members of the organization and other participants on this call, if you don't like anything you hear me say tonight, again, my name is Bill Herbert, and it's important that you email me, Bill Herbert, with any complaints you have for anything I said. Tell the mayor I said terrible things. Jim said at the outset, it's very important that we remind everyone that the organization is not designed to advise people, hey, here's the policy position we think you should take, or here's the opinion we think you should hold. Well, that applies to Jim and the organization. I'm a freelance, public servant and citizen. I'm going to tell you everything that I think you should think, and you can ignore me, and you probably should. But I'll also try to give you good, direct answers to your questions. If I don't know, I will tell you I don't know. And if some of my answers sound overly lawyerly, things like, well, it depends, or depending on which iteration of the ordinance governs, it's because I'm a lawyer, and that's the right answer sometimes. So for all that, I want to kind of give it back to Jim and Valerie and say thank you for inviting me. And thank you to all of you who've chosen to participate tonight. I appreciate your interest in your neighborhoods and the benefit of the city of Nashville as we continue to grow, continue to move forward.
Well, thanks, Jon Michael. And it would probably be helpful to remind people that you are not an elected position, and you also did not vote for any policy. It was policy enacted by council and impacted by other groups, but you are responsible for enforcing. And so you shouldn't be asked to change anything because that's not your role here.
Right.
There's a strong chance I'll agree with whatever change you think needs to take place. I have nothing to do with that. I don't get a vote on Tuesday nights at Metro Council. Okay. However, we do work with the enforcement laws we're given, the permitting criteria and permissions criteria that we're given, and we try to do the best we can to carry out that law. Think of it this way. If you have questions or comments that involve the word should, I think we should have a restriction on this. I think we should govern against that. That's your council member. Call them. If you have questions or comments or like, how do we do that? How do we go about that? Those do, which is action-oriented stuff, that's our group. And so I can hopefully give more directly responsive comments on those fronts. I hope that'll be helpful. No, I'm not an elected official. That was a deal when I got married. My wife said, we're not running for office. You're not going to do any elected office. And that was okay with me because I liked her a whole lot better than I liked the prospect of being a sad district council member.
Oh, okay, Jon. Well, then let's get started. I'm going to ask probably the widest open question that I've asked in this group. We really worked on this for years. Neighborhoods were split, and councils had endless debates, and even the state legislature got involved. Can you tell us today, where are we with short-term rental policy? What is the policy in this city?
So I'll speak most directly to law. The law says you can, period. If you are in a zoning district that allows it, if you're an owner occupied in the right kind of district, then you can have a short-term rental permit. If you're in certain zoning districts, you can have a non-owner occupied short-term rental permit. And we all understand it to be the investor type properties, right? Where I own a rental house across town from where I live. I do not live there. There's no question about that. Well, only under certain circumstances will I, as of today's law, be eligible for a non-owner occupied short-term rental permit. That's all locally governed based upon zoning district. Obviously, the grandfathering laws are very strong in this area. And if Valerie had a short-term rental permit back in 2016 in an area that would not be eligible for a permit today, if it were a new permit with a new owner, then she gets to keep operating because she's the owner. She owned the permit. And despite the fact that some local laws would have provided more coverage for her in a grandfathered scenario, the state law that was passed back in, somebody help me, May of 17, May of 18. I have aged quite a bit
17.
Since then either way, so I can't remember the year. But when the state law passed, it strengthened the grandfathering for people that were already legally operating with permits at that time. That's neither good nor bad. Frankly, the state law that was considered, and I'm so glad Jim referenced this, the state law that the legislature considered at one time in its earlier drafts was, it would have represented a big change the way we govern short-term rentals here in Nashville. And I'm trying to say that as benignly as possible. So I don't say my usual things like they're a bunch of hateful people that don't care about the poor folks, which, you know, you can agree with that, you can disagree with that, but sometimes those words slip out of my mouth. So I'm not saying that today. Instead, I'm just saying they were really aggressive about trying to preserve money-making rights for short-term rental operators at the state legislature. And they succeeded in passing laws that did that. So to Jim's good direct question, what's the state of policy today? State of policy is reflected by our local laws. You're allowed to have a short-term rental. If it's in the house that you own and you live in, I only have one of those. Everybody only has one that they own and live in regularly. You're allowed to get an owner-occupied short-term rental at that place. There's a lot of rules and regulations about how you operate that business, but you're allowed to. As for the non-owner occupied or investment type properties, there are also even more rules and regulations around that. And there are fewer places where today you would be allowed to get a new permit to operate in that manner. It doesn't mean that some very enterprising lawyers and real estate folks and developers don't bust their butts on a day and night basis to figure out every loophole they can to get around some of that. And they do have some success in that world. But we do have a pretty good rein on, if you're going to operate, you have to have a permit. And if you don't, we will clobber you. I'm not allowed to come burn your house down and call your kids ugly. I have asked, and they've not given me that right. But in the city of Nashville, thanks to some software that we use with a company out of Northern California called Host Compliance, now called Granicus. I think they went through a corporate merger about a year ago. We're really good at catching the people who operate without a permit at all, to the tune of roughly 96% compliance. For every 100 operators out there, 96 of them have the appropriate permit. Does it mean they're operating appropriately or within the constraints of noise regulations and other laws? Not necessarily, but just to the question of do they have a permit or not, we're over 95% every month when I run the numbers. And we're a big success story nationwide in that regard. We've been asked to speak at a number of conferences and presentations on behalf of various companies that are in the regulation business. And other cities say, how the heck do you do it? Like, well, you don't just have a guy named Bob in an office. You got to have some pretty complicated software to work on that stuff too. We do, and it works well. Sorry for the long answer to a good direct question, but I thought it might represent a good foundation or primer for what we're going to talk about tonight.
All right, thank you.
Mm-hmm.
Valerie, you're up.
Well, what is the year of the grandfather? Like what year is, is the cutoff for being a grandfather property?
So it's a smart question, and it's a good, concise question that does not yield a concise answer. The grandfathering is pinned for those who have short-term rental permits, you're grandfathered into the laws that were in effect on the date that you obtained the permit. And that's part of state law here. So if Valerie's short-term rental permit dated back to March the 1st of 2016, whatever local ordinance here in Metro was in effect on that date, That's the one that governs and that you're grandfathered into. So if there are a bunch of other changes in laws about eligibility or permitting criteria or anything like that, that is where you're going to go back and say, okay, well, what was the law when Valerie got her permit? Oh, it was, I'll make it up. Council Bill 2015-483. Great. We'll go back and review that to make sure the eligibility criteria are the same. If she has to appeal something about her permit, it's going to be governed by this law. We need to look at that law. So because the Metro Council has passed, you know what? I don't have my files in front of me. It's more than a dozen laws since this took effect in April of 2015. I think we're at 15 laws that have passed. The state has passed one. We've been through more lawsuits and decisions in courts than I care to count. I don't remember from one day to the next. I've got to stop, research it, go back, find the ordinance, and apply it accordingly. So for members of the group, Valerie's question is dead on the money. What are we going back to in terms of grandfathering? We're going to whatever law was in effect the day you obtained your permit.
Okay. Okay. So you were talking about this program that you guys are using now, Granticus.
Yeah.
Is that what you said? So
Host
on a
compliance.
daily basis, how many permits are you all processing?
I look at it on annual numbers usually. Right now in the COVID year, obviously we spiked downward in March, April, May in terms of permits issued. But for new permits issued, it's back around 100 a month right now. A few will roll off the books each month as well. People just not want to fool with it anymore, or people failing to renew as they're supposed to. But citywide, I checked the numbers last on Friday, and the number was 4,964 short-term rental permits in Nashville. And that represents about 96%, approximately 96% of the total number of short-term rental operators or operations here in Nashville. So how many per month? It's around 100 here in the last 2 or 3 months, but we're floating with around 5,000, give or take, citywide right now.
What is that process, the permitting process?
One, file an application with the Metro Codes Department. That is done via email. So if Valerie doesn't have a permit, she's going to email my work colleague. I mean, this is all on the Metro website, by the way. The individual within our office is a man named David Frabut. As he always says, it's Frey with a long A, and then the thing you sit on, David Frabut. His description, not mine. You would email Dave and say, I want to apply for a short-term rental permit at 123 Main Street. He walks you through all the information that's needed, the documentation, and that has everything to do with a copy of your deed showing that you are in fact the owner or who the owner of the property is. It will involve certified notices going out to your adjacent property owners showing them, hey, I'm notifying you as required by law that I intend to apply for a short-term rental permit. And that's fine. It's not a permission. It's just a notice. He'll walk you through the other requirements as far as show me the copy of the insurance that meets the requirement, et cetera, et cetera. The slowest part of that review is waiting then for the fire marshal to come out and do a walkthrough and inspection of the subject property and confirm that it meets all of their guidelines. Just because they're so darn backed up and have so many requests on their time, it takes them a while to get out there. So soup to nuts from the first day you apply to the day you actually get the final approval and pay for the short-term rental permit, it's usually about 3 weeks, give or take, on the turnaround time. I thought I saw a text come through with a good question about how long does a short-term rental permit last? All short-term rental permits from the very creation of them in 15 to present day are 1-year permits, 365 days. So people who tell me, well, my permit expired and I screwed up and now I need to, I'm not sympathetic to that. I know how to mark a dang calendar. My 6-year-old knows how to mark a calendar. I know that because she's had a countdown going for her birthday that's 10 months away for I don't know how long. Most of us grasp calendars. And especially, here's where I'm unsympathetic. If you're running a small business or maybe a not small business, making a lot of money, and the only way you're able to keep running that business is by having this short-term rental permit that's a 1-year permit, buddy, I think I could put it in my Microsoft calendar. I think I could get it on there. So if I sound unsympathetic, it's because I am. And, you know, sometimes I'm the voice of no on behalf of the Metropolitan government. And who, buddy, I like to think a handful of these neighborhood groups would be glad to hear it because there's a few of us still at the gates keeping the barbarians away.
Right. So if you already have one and you need to re-permit it, is that process the same?
Similar, but not identical. You basically are just going to submit a sworn affidavit confirming that, yes, I'm still the owner of the property. if it's an owner occupied, or yes, the ownership is the same. Yes, I have kept up with my taxes as required by law in terms of the hotel motel tax, the property tax, et cetera. And there's been no other substantive changes to my permit. So once you provide the affidavit confirming all the things we tell you have to confirm, and you pay the fee, and you do so before the expiration date of your 1-year permit, you get it today, that's April 22. You need to have that to us next year by April 21. The reality is law now creates a 30-day grace period on that, but still don't mess with that. Don't cut it close, get it on in. If you go through that process, then that's the renewal process. And frankly, it's easier because you don't have the fire marshal coming out to inspect all over again, and otherwise slowing down your process.
Right, right.
So,
Let's-
hey,
let's
Valerie,
yes.
we got a couple questions coming in around
Okay.
that.
Sorry.
Helen wants to know, are there a limit of how many STRs can be in a council district, or what are the limitations around that?
Very smart question. And hi, Helen, thank you for a smart question. The short answer is no. The original iteration of the law had restrictions on how many short-term rental permits, specifically the non-owner occupied permits, could exist within a census tract. And that's an even smaller little bite than a council district or something like that. Just to be perfectly frank, it was hard to track. We built out a software program that tracked it, and we were able to halfway stay on top of it. But later iterations of the short-term rental law no longer had that restriction because there were more restrictions pertaining to actual zoning districts and things of that nature. We kind of didn't need it as much. There were already restrictions in place that kept people from going nuts and having 1,000 non-owner occupied permits in one little neighborhood. I know it probably feels like there are that, but there really aren't. I've got the heat maps, I see it. So no, there's not a restriction based solely on neighborhood, council district, street, census tract, or anything like that. But the current iteration of the law includes such restrictions on zoning districts that you get kind of a de facto restriction in that regard. Sorry for a long answer, but that's an accurate answer.
And Michael wanted to follow up about owner occupied. So if a
Mhm.
person occupies their home and has a
Mhm.
dadu in the backyard, does the
Mhm.
dadu qualify as owner occupied?
Either can. If you've got a dadu in your backyard, the classic example is west of Gallatin and East Nashville, okay? Because there's that whole big, it's a de facto overlay where a lot of people are allowed to get dadus built in otherwise single family zoning. You can either rent out the main house or the dadu. You can't do both. You can only have one permit on the property.
Will you
And
say what a
honestly, we don't
dadu
care
is,
which.
John? Will you say what a dadu is? Some folks may
Oh,
not
sorry,
know.
a dadu, that's a smart question, is when you've got a detached dwelling unit in the backyard, if you think of it that way. D, detached. A, accessory, kind of subject to the main structure, your main house. The second D is dwelling, and U is unit. So dadu, detached accessory dwelling unit. You have to get a permit for that structure. You have to have legal permission to have that second dwelling on the property. They are owned the same way. So if John owns the main house, John also owns the dadu unit in the backyard and cannot separate ownership of the two. It's not like a HPR or a two-family thing where I can sell it off to my friends so they can live out there. I can rent it, of course. I can even short-term rent it if I'm eligible for and obtain the permit. But they are considered tethered, if you will, in terms of the ownership requirements.
Mhm.
So can I get a short-term rental permit for the dadu, the small dadu unit in the backyard? Yes. Can I get a short-term rental permit for the main house and stay in the dadu unit myself? Yes. Can I have a permit for both and come and go as I please? No.
All right. So back to the single dwelling house. What
Mhm.
happens if they get their permit and then the owner moves out of town but continues to operate as a short-term rental?
So at that point, you have changed the owner occupied status, right? They legitimately move out of town. They live in their new house in Seattle or wherever. And Seattle Steve ain't coming back. He's just renting it out. It's a matter of us catching it. Now, ownership didn't change, right? It's not like we can check the register's records and get that. There was a short-term rental permit, so we don't think anything of seeing short-term renter activity going on there. No big red flag for us there. We don't know if Steve moved away to Seattle. So we're reliant then on neighbors Like, this is where we're okay with the busybody neighbor who in many occasions might wear us out. It's okay. We're okay hearing from them in this instance because we don't know. Hey, Steve moved away and he no longer lives there. The full-time resident is, Randy Renter, who just moved in there back in January. And he's been there a couple of months and he's fine, but it's clearly not an owner-occupied scenario anymore. That is basis for, if I say termination or expiration or cancellation of the permit, not as a punitive measure, just as an operation of law. You had an owner-occupied permit. You're no longer an owner-occupant. That permit must die. You're allowed to apply for a new permit, like non-owner-occupied, if you wish. And if you're eligible for it, meet all the criteria, then you'll get that permit. But if not, I don't know, tough break, Seattle Steve. You left. That's your problem. Where do we report violations? Matthew asked, I want to throw that in. Hub Nashville. Surely to God, on this group, you've talked about Hub Nashville before.
Now, what is Hub Nashville?
It's a brainchild of the Barry administration, a centralized point for sending your complaints about bad traffic conditions on my street, about I think we've got a non-permitted short-term rental next door, about noise complaints, about I've got standing water in my yard. I need to know if I'm supposed to do something through Metro Water and Sewer, about I don't know, Jim Hawk keeps knocking on my door day and night. Can you get somebody out here? Whatever the case may be. And we all know Jim does that from time to time. Okay. Whatever it is, Hub Nashville, it's all identified through the Metro website, which is nashville.gov. And the idea of the hub is it's a centralized location to receive all these inquiries or complaints and make sure it's a mayor's office staff position. They farm those issues out to the correct departments. So if it's something for short-term rental and you don't know any different because maybe you're new to town, maybe you send that to the police. Well, they don't give two hoots about that because it doesn't involve them. It involves us at codes. So Hub Nashville receives this complaint to their centralized complaint location. They're going to send it to us at the codes department and we'll know what to do with it. So complaints to Hub Nashville. The recipients of that complaint will know where to send it, so you don't have to figure that out. It's amazing how often we'll get a complaint about, damn it, there's water standing in my front yard, codes. What are you going to do about it? I'm like, well, I'm not going to do a damn thing about it. It's what I'm not going to do because I'm not water department. I'm not stormwater. This road there's terrible potholes, codes. What the heck are you going to do about it? Again, I'm not that group. I'm not going to do anything. Send it to the right place. We'll get it to the right place. No problem. So use Hub Nashville. It's a good resource. Again, credit to the Barry administration. That was their idea.
Yeah, let's talk real quick about enforcement. So
Sure.
people like we're folks calling Hub Nashville, and they because there's an issue. So then what do you all do?
So if we get a complaint, our property standards division, which is kind of like the codes enforcement division, will inspect. Their job is to figure out what's the nature of the complaint. Well, we think there's a non-permitted short-term rental operation over there. Okay, let's check. What's the address? Okay, this is the address. Is there a permit at that location? No. Okay. If there is short-term rental activity taking place, then it's not permitted and therefore illegal, and we need to clobber them through the environmental court system. All right, that's fine. It's a matter of them being able to have the right evidence in hand, right? Like we had a smart question about what if the owner-occupied status changes and Seattle Steve moves away? Our job as a city government is then to figure out how we're going to prove in court that Steve is no longer the occupant. Think about that. You got to prove it in court. So what's going to be proof? Maybe utility records that renter Randy is now living there and all the utilities are in his name. Maybe photos and videos from the neighbor of the other person's driveway showing that Randy Renter is the only person there. His car is the only car there. He's the only person coming in and out every day. It's a little invasive, but yeah, that's one way of proving it. So the proof can be tough. As a result, the enforcement can be tough because we're still held by due process, by the requirement to provide evidence to a judge. Having spent a number of years in that very environmental courtroom, winning a hell of a lot more cases than not, it's because we had the goods. Then when short-term rentals came along, proving owner-occupied status was a sham on somebody's part, buddy, that's hard. Short of me being like your college freshman dorm RA who's knocking doors every night saying, hey, who's in here? I mean, I guess I could do that, but you do not want to pay me what it would cost for me to go do that because it would be completely unreasonable amounts of money.
Well, that's a good point. We would have folks complaining that, hey, they're raising hell all night.
That's right.
And so by the morning, it's all cleared out. And so
That's
then
right.
what,
Well, so noise complaints are uniquely, for a variety of reasons under the Metro Code, the province of the police department. But in fairness to them, if there's a bad wreck at Nolensville and Harding, if there's a freaking bank robbery in process up on Gallatin, and there is a terrible domestic violence situation way out in Bellevue, am I really worried about going to see about, Wisconsin Wayne and them that are getting a little too rowdy on the back deck of some short-term rental house in 12 South? No, that is the lowest priority out of those four. And for every 100 calls that come into the police department, short-term rental making too much noise at night, though a legitimate issue and concern, is almost always going to rank way down on the list of 100. And they at the police department, and again, I represented them in the past, they've got to tend to those health safety, life safety type issues first, and then work their way down thereafter. That's just a necessary part of every city's police department's jobs. So we in the neighborhoods are going to struggle a little bit in that regard. And, theoretically, could the codes department employ overnight codes inspectors to go handle codes complaints, like noise complaints? Theoretically and on paper, yes. But, if you come to my house at 100 o'clock in the morning, knocking on the door, I don't know what's going to be in my hand when I answer the door, because I might be a little worried about who's knocking on my door. And if you even come at 10 o'clock before we've all gone to bed necessarily, I might have had one or two. And we call it the Bubba issue. And forgive my frankness here. Do I want my codes inspectors out there knocking on doors on Friday night at 10 o'clock when Bubba's had a couple? And maybe he's not real intrigued to have government come knocking on his door saying you need to dial it back, or you've got these issues. No, our codes inspectors aren't armed. They're armed with what? A clipboard? That's not going to get you very far if Bubba's not in the mood for it. So we don't want to be in that business. But it's a legitimate question. We've got these noise complaints, bad operator type complaints. Valerie's right. If the police make it out 3 hours later, they're probably drank enough that they're sleeping it off. Or if they come out the next day, well, of course, all the noise is gone. Heck, they checked out at 10 a.m. and they're on the way back to Wisconsin now. It's a tough element of this. Yeah. And short of me being your neighborhood resident assistant in the dorm, it ain't getting caught.
Mm-hmm.
Hey, John, we got a couple more questions from the audience. It's really strange. Usually people shout them out, but tonight everybody's texting, and that's okay. We'll do it. But someone wanted to know if you can clarify the rule around owning both sides of a duplex or townhouse in order to have both. Can you get to that?
That law has changed 2 or 3 times. It's been subject to some litigation or whatever else. So, and I'm sorry, I don't have ordinances in front of me. I'm going to be real careful here. My best recollection of the last iteration out of the 15 ordinances that have passed regarding short-term rental eligibility, and if that feels like a huge caveat, it's because it's a huge caveat. My best recollection is that it's still a requirement that the ownership of both sides of a duplex or HPR, 2-family use on the same property, right, has to be the same in order to obtain a short-term rental permit. Modifications were sought to that last year. Sitting here in a car in East Nashville, I don't remember what passed on that. Whomever asked the question, you've asked a smart question, email me and I'll tell you. I'll send you a copy of the ordinance, no big deal. You can look it up yourself at nashville.gov. There's a bill search feature on the Metro Council's website, and you can just search all bills pertaining to short-term rentals and you'll find it yourself. But that's a little cumbersome for the average person, and that's fine. If you'll email me, I'll be happy to try to find it and send you that ordinance so you can see it, black letter law.
And I've put Jon Michael's email address in the chat.
That's right. It's bill.herbert at nashville.gov. Bill.herbert.
You keep trying to pull that off, John.
I think I just got my pay decreased by 20% for saying that.
Janet has a question. Can you receive an STR permit if the owner lives across the street or next door?
Potential. Oh, you mean if your neighbor has a short-term rental permit, can I still get one? Or is the question, can I get one if I don't live in that house?
Janet, do you want to speak?
Yes, the question is, if I don't live in the house, but I own the property across the street or next door, can, because I'm really close, I'm less than, 100 yards away.
Got you now, Janet. I understand your question, but thank you for clarifying. That helped me. Okay. And thank you for joining us today, Janet. I appreciate you for that. The short answer is only if the property per its zoning allows a non-owner occupied. Because think about it this way, Janet, you live in house number 1, and maybe you own house number 2, and it's on the same street. Heck, maybe it's across the street. Maybe it's next door, but you don't live in that one. You live in house number 1. So
Yes.
only if the zoning allows for a non-owner occupied, meaning the occupant is not the owner, you, Janet, don't live there, only then would you be able to get a short-term rental permit. But if the answer is yes, the zoning allows for it, then yes, you'd be able to get it.
Okay, thank you.
Sure.
So I got one more here and then we'll get back on track with Valerie. But Ingrid wants to know, what's the penalty for STR violations? Like
I
not
come to
having
your
a permit
house,
or noise?
I set it on fire, I call your kids ugly, and I kick your wife in the shin or spouse. That's what I've frequently proposed to the Metro Council. They've yet to take me up on it, but I think it's justified in some instances. What is the penalty if you operate without a permit? You are penalized by not being allowed to apply for a permit, let alone get one, even apply for a permit for a year. A lot of people appeal that to our newly created short-term rental appeals board. Think Board of Zoning Appeals, but just for short-term rental permits. Newly created, I stood on my head for 4 years trying to get that built. It's now built, it's up and running. They met yesterday and heard a bunch of cases, so that's good. But the penalty is you're not allowed to apply. Then if you operate without the permit, you're subject to going to environmental court and getting hit with a $50 per day of violation fine, and also a court order saying thou shalt not. And you say to yourself, what the heck with a court order? Who cares? Here's who cares. The person who keeps violating after a judge said thou shalt not, because now you're not getting in trouble for operating with a short-term rental permit. You're in trouble for violating a court order. And if the city can prove that you willfully violated a court order, that's called contempt of court. And the punishment for contempt of court is an orange jumpsuit down on Harding, meaning you will spend 3 days in jail, and I will laugh at you the whole time, because it is a different level of dumb to get arrested and put in jail because you wouldn't quit operating your short-term rental permit when a judge told you to do so. I've got no sympathy for that. And there's an unfortunate person here in Nashville who not only got put in jail for it, then appealed, kept operating while waiting on his appeal, thus further violating the court order, causing the appellate judge to say, you're so dumb, you not only have to do the first round of time you did, I'm going to give you some more time. And again, my sympathies are absolute zero on that. If a court order tells you to go home and stand on your head and sing the Star Spangled Banner in French, you better figure out how to do it because you got a court order, cousin. If the judge says thou shalt not operate a short-term rental, then knock it off. Go to jail if you can't figure that out. Well, can I just pay a fine? I'm making a lot of money over here. No, you can go to jail is what you can do. And we're going to keep coming after you till you quit.
Yeah.
So another question came in. So when you just mentioned that there's a new court established, is that court like the planning appeal court where neighborhood organizations and residents get a chance to testify, or is it simply lawyer to lawyer type stuff?
So it's a new board, not a court.
Okay.
And I know that for some that'll sound like semantics, but I promise it's not. Is the new short-term rental appeal board. You can find basic information about it on the Metro website, nashville.gov, along with all the other boards and commissions. It works like the Planning Commission or the Board of Zoning Appeals. It's much closer to the Board of Zoning Appeals in function. 6 independent Nashvillians and 1 sitting council member appointed to the board and approved by council. And they hear cases where people file appeals saying, I got dinged for operating after my permit expired. I'm hit for 1 year, not allowed to apply for 1 year. I'm asking this board for permission. Please reduce my 1 year to half that or to nothing because here's my circumstances. And to Jim's question, yes, members of the public can come in and say, I'm familiar with this case, this property, this operator. They've been a good operator. This looks like it was just a oversight in managing their calendaring and their books. I don't think we should hit them for a full year. Or in the alternative, I'm here to tell you that this operator is a dirtbag and they've been running a terrible short-term rental operation. They've skirted the rules every chance they've had. I think you should hit them for the full year for sure. And that's fine too. So it is a public hearing open to the public to just come sit and watch, to be a participant as an opponent or a supporter of an appeal. Either way, it works a lot like the BZA. And it's my understanding yesterday's meeting of the short-term rental appeals board is already up online. If it seems clunky, if you look at it and it seems a little like convoluted, it's because their very first meeting in person and their very first meeting to have any actual hearings. So we're all learning as we go.
Okay.
Mhm.
So I got a question from Ed. And this is very specific, I believe. Are STRPs allowed in a formally zoned RS5 property, like in Scott Davis's SP in McFerrin Park, Cleveland Park?
So smart question. That's
Ed's known for
it's my
those.
boy. It's you hit on a gold mine there. We have definitely spun our wheels on this in the past. I hate that SP more than any SP in the city because it's not really an SP, is it? It's really more like an overlay. Hey guys, you're allowed to have a dadu over here. Again, the detached accessory dwelling unit. My recollection is, first of all, if it's owner occupied, yes. If it's the house that Jim Hawk bought and Jim Hawk lives in, and it is the Hawk family property where the Hawks live, yeah, absolutely, you can get an owner occupied permit. But as to non-owner occupied, a residential single family zoning district is not allowed under the law right now to get a non-owner occupied permit. So the SP component of it is going to kick its way down to being analyzed as though an RS5 in the very specific instance of the old Scott Davis SP over there in kind of the Cleveland Park area. I know that's a little bit of a specific answer to what might have been intended as a broader question, but SPs are a weird animal, and because they are administered exclusively by the Metro Planning Department, we are quick to kick over eligibility questions within SPs to the Metro Planning Department. They want that badly to manage them. My God, we're glad to let them have them.
So Pam wants to know the length of time. What length of time defines short term?
Smart question. I forgot to say thanks to Ed for his good question. Pam, that's like the defining element on this, isn't it? 30 days. If you have a stay of 30 days or less, that is short term. And any paying guest in this certain residence for 30 days or less means you as the owner better have a short-term rental permit. So a lot of times when people are getting ready to try to apply for their short-term rental permit, they'll go ahead and list with some of the platforms where they can advertise their property, but specify in big letters, this is for 31 days or more, only for long-term renters, 31 days or more. It's not a short-term rental. And the reason they would be motivated to do that, even though they really want a short-term rent it, is because this is a way to get their property out there, get pictures of the house or the interior. It's a de facto marketing effort, right? Advertising, Valerie's new album is dropping on Tuesday. Well, you can't buy it today, but if she's got billboards all over town, we're like, damn, we got to get hold of that Valerie album. I know I've said that 1,000 times about Valerie's music. So you should too. And that's a good deal for the 31-day listing, right, on the platforms. So 30-day is the magic cutoff. Long answer to a good direct question. Sorry for that.
Mhm.
So strategy question from the other side, Jon Michael.
Okay.
How can STR hosts protect themselves against neighbors who file false claims against them?
Win in court. Demonstrate that you're in the right and that you're clean. Keep books, keep logs, know your rental dates and your rental times. Be good at what you do with your business. So a false claim would be, well, there was a bunch of noise out there. Well, did you call HUB? Even if it's a non-owner occupied, you're required to, if I live in Denver, right, and I've got short-term rental properties here in Nashville, and it's all legal, and I've got the permits, I'm required to have a local representative within 25 miles of my property, such that if there is some problem at 100 o'clock in the morning, then Mike, the manager, can buzz right over there and deal with it. The pipes got burst, or there was a big party and the police got called out, or some awful thing. Mike can deal with it because I'm in Denver and I got to have somebody local. So if I'm the operator and I'm choosing to use a management company, do your homework, get a good management company. Anybody on this call ever had a really not particularly effective real estate agent? Of course, there's somebody that has. You ever had a really great one? Of course, some of you have. And you know the difference, right? It's no different with these management companies. There's crappy lawyers and there's good ones. There's dentists who see every problem as a let's pull the tooth, and others who say, well, let's see if there's a more intricate solution. Every line of work has good ones and bad ones. If you've got a crappy property manager, you're going to spend time with me eventually. And no offense, but I don't want to see you, and you don't want to see me. I'm the face of bad news for short-term rental people. Generally, I'm rarely the face of good news. So how can I deal with false accusations? It's pretty hard to demonstrate that they're false, but don't be hesitant to work with an attorney who can represent you on anything that makes it toward court. And if somebody goes to the level of like, look, man, I've only had this permit for 2 years. They have lodged 12 complaints in 2 years. I've been to court 3 times. I've been found not guilty on every charge they brought forward. Then you can consult with your attorney about whether or not there's some legal action to take to try to prevent them. The trick is, it's a hell of a thing to say you can't complain about a bad action. You're no longer allowed. Because the idea is one day, even if I am a good operator, I'm not there. My tenants really might be dirtbags doing rotten things and we can't get it addressed quick enough. And now this poor neighbor who I've said, you know, I've got a court order saying thou shalt not mess with me anymore, but there's a legitimate thing. You can see why courts are hesitant to go down that road. But it's always okay to consult with your attorney and see if there's a private cause of action against the individual or individuals who are doing something like that. That's your
Right.
free legal advice for the day. I'm not even supposed to be giving that.
Jon Michael, we're running up on our last
Yeah,
few
we
minutes,
are.
but I got one
But I
last
just got
question.
started. I've got so much to say.
I got one last question in the queue though, and this goes to HOAs, okay? So if a homeowners association has passed a rental amendment that does not allow short-term rentals,
Good job.
will the city take that into account and refuse the permit?
2-part answer. First part, we don't do HOAs. That's a private contract with private parties. It's John and his HOA. It's Jim and his HOA. It's Valerie and her HOA. Y'all figure that out and go sue each other in court. Part 2, the only exception to that in the entirety of the Metropolitan Code of Laws, much to my chagrin, is that the council put it in one of the umpty 4 million short-term rental laws that if the HOA says, no, you can't, then no, you can't. We will acknowledge that. The trick is when Jim comes in to apply for a short-term rental permit, if I don't know that he's in an HOA, which I don't, and I don't know that that HOA has rules regarding this, and I don't know that Jim's application is going to bump up against that, and I don't, Jim's probably going to walk out with a permit application with a sign off from us on his way to getting a permit. So what needs to happen is when the HOA or an interested neighbor or whomever figures out, oh crap, Jim's over there getting a short-term rental permit. He's not supposed to be able to get that under Rule 26B and the HOA covenants. Then you got to get that emailed to us, not just the sentence, but the whole document, because we got to be able to read it in context. That's just, again, nerdy lawyering stuff. And determine, yes, the HOA does restrict that. The section of law in the Metro Code that governs this does apply here. And we can see that that is just something they're not allowed to have. We'll then wind up revoking the permit based upon that legal requirement. So although I will not touch an HOA with a 100-foot pole, this is one where I have to. And so you got to get me that info if you find out somebody's operating.
So Jon Michael, I made an error. I thought you had addressed this question, but someone brought it to my attention that we didn't get to it.
Okay.
This goes back to the question about violators getting their renewal permits. How do violators of STR requirements continue to get renewal of their permits?
Well, violator can mean a couple of different things. If you got hit for having a noise complaint, that's effectively strike 1. You don't lose your permit. You're still allowed to renew. If you get 3 strikes as defined under state law and the state ordinance, the state statute makes it really hard to get 3 strikes. I think I mentioned to you that the state law that was passed was very operator friendly. It was drafted by the lawyers for the industry. It was pushed down the throat of legislators who are extremely business friendly, private property rights friendly, and thus short-term rental industry friendly. I have literally, since that law passed, not killed 1 permit on a 3 strikes basis because I haven't had the facts under that body of law. How do they continue to operate? Because unless you got 3 strikes that meet the state law definition, I can't kill it. And you're still eligible for renewal. That's the short answer and an accurate answer.
Well, Jon Michael, thank you so much for helping us better understand the permitting and enforcement. Really informative this evening. Thank you so much.
Sure.
Audience, thank you all for all your great questions and comments regarding it. I'm going to ask Jim to talk a little bit about C4N before we rock and roll.
So I don't want anyone to leave here tonight without knowing about C4N Nashville because it's coming up on Saturday, May 15th. If you've never heard of it, it is a 1-day training and networking opportunity for anybody who wants to make a positive difference in their neighborhood. And I just encourage you to attend this year. We have over 25 workshops, facilitated conversations, panel discussions, presentations on 8 different neighborhood passions. And the mayor will be one of our keynote speakers. The chief of police will be there speaking about his philosophy in neighborhood policing. And then we have this huge amount of neighborhood and community leaders. There's over 50 neighborhood and community leaders who are on our faculty for this event. And they just have a huge amount of experience. So I really want to encourage you. I've just put in the chat the link to C4N Nashville. I truly believe that this is one of these events that if you attend, you will find fantastic comrades who are really, and maybe I shouldn't use that word, but colleagues and comrades and friends who really care about their neighborhood. You will be able to get some real good leadership tips and really good practical skills and knowledge to really help you grow to make a difference in your neighborhood. So please make sure that you sign up for C4N Nashville. The registration deadline is May 10th, so it's coming quickly. No one will be turned away for lack of money. It's just that important. So check it out, and I hope to see you all there.
All right. Thanks so much tonight. Please join us next week for Edward Henley. He's going to talk about how to keep your long-term residents. Remember, great neighborhoods don't happen by accident. Find your neighborhood passion and work hard to make your neighborhood a safe and vibrant place to live. Good night, everybody. Bye.
Good night.